Welcome, ladies and gentlemen, to our episode 6 of African Real Estate Podcast. And here we explore the dynamics of real estate. My name is Dominic Mwangi, alongside
Victor Kiplagat.
We have to first of all appreciate your continued support to our podcast, and we believe that you have learned a thing or two. Thank you so much.
Today we have an interesting topic about the will.
What a will is it important? There are types of wills. How do you navigate around a will? And that is our episode 6. As we have said, a will is a legal document that puts down or sets forth one's desires on the distribution of property after their death. However, when one dies without a will, the property is automatically distributed to the next of kin, the deceased spouse or the children, or maybe the parents if it was for an unmarried person and such. In the latter, that is when one dies without a will, the decision entirely lies with the judges or the state officials.
Very well put. A will contains the direction for assets and dependents once the one who bears the will has passed on. In layman's language, this part of property will go to this person, this other property will go to this person, this part of the estate will go to this person, and so on and so forth, right?
Exactly. I would like to expound on some four terms that maybe we might find ourselves using as we try and navigate through the will.
Great.
The first term is estate. So estate is the property that is owned by an individual at the time of death. That is estate.
All right.
Testator, this is the person leaving the property behind. When we are talking about writing a will, the person who writes a will is called a testator.
Testator, all right.
The third term is testate. This is when a person dies having written a will. And the last term is intestate, when one dies without a will.
Incredible. Why you should have a will? Why is it important to have a will? You can be clear about who gets your assets. You can decide who gets how much in terms of percentages, or as an attorney will be mentioning while reading the will. You can keep your assets out of the hands of people you don't want them to have them. Maybe an estranged relative or people they get hands on the estate or the property, they'll not put it to good use. You can identify who should care for your children, who should be in custody of the children if they are young. It's important as this will give your heirs a faster and easier time in getting to your assets.
To expound on a point that you said, you get to decide on who gets what and who does not get. For example, let's take an example of an ex-spouse. This spouse may wish to benefit from your inheritance despite the fact that he or she is an ex. Having a will explains this property will go to this person, and for example, you have not listed some properties. You will also have to say who will benefit from the unlisted properties. Having a will helps one make a decision and save the heirs from being exploited.
Exactly. And it also saves the family of the emotional strife, the court struggles, emotional tussle. It might even be shameful of a famous family because of a property worth billions. A will is really an amicable way of solving property disputes.
And it also saves time as well as money. For example, take an instance. You are going to the courts. Before the case is decided, who is managing the property? Maybe the property is already running into losses. The whole legal battle will have a cost to be met at the end of the ruling. But who will meet this cost? This cost will be met from the same property. Having a will save a whole time as well as expenses that may accrue from a legal battle.
True, and you know that legal battles are expensive. To get proper lawyers, you don't pay peanuts to win a case.
Especially in Kenya, you might also find that part of the property ends with the lawyer. And also, having a will helps one decide on digital assets. For example, we have a lot of digital assets. You hear people talking about bitcoins. People have YouTube channels, Facebook accounts, and having in mind that business is online. When one dies, for example, and they have a YouTube account, this account pays some money. Who will be getting this money? Having a will explain everything. Who will benefit from the pay? Who will be managing these social accounts? There is this West African content creator who just passed on some few weeks ago. Soon after the death, the stepdaughter took over the account. Maybe it was in the will that this daughter is the one who will take over the account. Maybe he wrote in his will that way. A will saves a lot of things. There will be no contest over such assets.
Exactly. It's also important to point out that a written will is signed in the presence of witnesses, because if there's no witness, there's no case. I mean, that is very obvious.
True. If there's no weakness, there's no case. I like the way you put it.
Sure.
Lastly, you find that when you do write a will, you give the instructions, what funeral you would like to be accorded. For example, there are people who wish to be cremated. There are others who wish their organs to be donated. Various wishes. So having a will explains without contradiction how you would like to be accorded the last respect.
True. We'll look at types of inheritance will. Holographic will. These are handwritten by the testator when the time is short and the witnesses are unavailable, or when the one bearing the will is in a life-threatening accident, someone is sick and has been given a short time to live.
In addition,
Yes.
you find that in many instances, the validity of this will, the holographic, may be challenged because who will prove that it was written by the testator? There is a thin line between accepting this holographic will and challenging it in a court of law.
I'll have to mention this on a light note. If it was written and everyone got a fair deal, fine. But if it was written and someone got a raw deal.
But you also know, Victor, that what you call a fair deal may not be absolute. What you call fair may not be fair to me.
Yeah, sure. Depends with what is quote unquote fair.
There are high chances of challenging.
Wow. Oral wills. This is when the one bearing the will speaks their wishes before witnesses.
Understood. Actually, that is very clear.
For over will is used in conjunction with creating a trust fund into which your assets will flow. From the word pour over, someone might decide, because I didn't have siblings or I didn't have children, I will create a trust fund where the assets will flow either into charities or into children homes or into environmental conservation purposes. That is also a bit rare in this part of our country.
Sure, it is rare. However, it is also much used by people who fear beneficiaries of the property will mismanage it. So majorly, they create the trust fund.
Exactly. Mutual will. A married or committed couple usually execute this type of will, whereby if one party dies, the remaining party is bound by terms of the mutual will. Maybe this couple had an adopted child. They want to make sure that apart from the biological sons and daughters, even this other one is not given a raw deal. It is fair and square.
And whoever is left must abide.
Sure.
Particular will that is most common. This is called the testamental will. So this is the type of will where you prepare a document and append your signatures in the presence of witnesses, and one should be very careful to ensure that the will is correctly worded and is in line with the law to prevent contestations in the court of law by the mentioned beneficiaries of the estate.
Very true. When you have a will, it means that the assets will not be mismanaged. It is traditionally cheaper to prepare than having an estate planning instrument or court cases or a judge or a court of law trying to put into arrangement how the properties are going to be shared among the family. Also, a surviving or an unmarried partner will have no automatic claim to any part of your estate. Someone from the court of law might say the legal basis for this argument might be that because you are married, you want to take advantage of the property. Having a will, you can benefit charities.
Sure. We will finalize by looking at some of the characteristics of a will.
Sure.
A will must be ambulatory. This means that the will must only speak and only becomes relevant after the death of the testator. We also have revocability. A will can be revoked by the testator if he or she has the capacity. When you have prepared a will and you have not foreseen some circumstances and you still have the capacity to revoke it, you are in good state of mind and mental health, you have the power to revoke it and prepare a new one or change some parts to a different standing. There are also formalities. The law provides for guidelines on how a will can be prepared, that is, the witnesses, signatures. The testator must be of age. Another characteristic is that the will must be prepared by the testator himself or herself and signed by them.
All right. In making of a will, you will work with an attorney who will write it in person, because the attorney or the lawyer understands the nitty-gritties of the inheritance or property law. If a will leaves less to a spouse, then the state law requires that part of the document can be overridden so that the spouse will be awarded the mandated amount or the fair one, so to say, quote unquote, what is fair. The attorney will administer the will. It's important to note that the case of engaging an attorney is important when you have vast estates, large tracts of land, or when property transfer and ownership is legally complex. The case study, the Kirima family, the sons, there were some massive estates that they had misused of Gershon Kirima, and also the firstborn daughter, some other siblings wanted to take their father, that is the late Kirima, for some mental checkup to see if he's fine. But one of the lawyers was saying that they wanted to take him to the hospital so that he could be declared unfit or insane, so that property ownership could be escalated towards their side. Also, the case was updated 5 months ago. The legal ownership of the land was for the Kirima family. So you find that there was very many people who they had to be evicted after they were given notice of eviction, so that for that was of the Kirima family would be belong to them. Finally, reviewing of your will is done every 2 to 3 years and at pivotal moments in your life when you want to review your will, either in adding details or minor details of the will. And these pivotal moments might include marriage, divorce, or even beautifully, the birth of a child.
Maybe you never foresaw their birth during preparation of the will. So when they come, definitely.
Yeah, on a lighter note, the birth of a child is a blessing. And, there's a times maybe people don't foresee that I will have a bundle of joy in the future. They're just amassing properties and having fun.
I know. I have also learned a lot of things concerning the attorney, the case study that you mentioned about the Kirema family. And having learned a lot about the will, can just wish them happy Easter holidays. Believe they had an enjoyable Easter.
Yeah, sure. Happy Easter to our favorite listeners of the African Real Estate Podcast.
And enjoy yourselves. That is it. That has been our episode 6, and we look forward to seeing you in our episode 7. I have been Dominic Mwangi alongside
Victor Kiplagat, your favorite co-host.
And until next time, see you.
See you.